Welcome back. I'm the Intense MD, a double board certified intensivist, here to give you an inside look into the intensive care unit. Today we're going to discuss who would make your medical decisions if you're not able to. Many times in the intensive care unit, we'll have a patient who comes in already on life support. Sometimes they might have been found collapsed, or they just, come in alone and get worse in the emergency room and then need to be placed on life support. Before I put somebody on the ventilator, if they're able to talk to me, I ask them, if you can't talk to me, who's going to make your medical decisions? But there's many cases where we can't have this conversation beforehand because things are so emergent. So there's two different ways of going about this. The first is finding out if the patient has a medical power of attorney. This means that they filled out legal paperwork that designated someone to be their medical decision maker in the event that they cannot make their own decisions for whatever reason. This is part of the process of making your advance directives. So part of that process is assigning one person, and typically an alternate person as well, to make your medical decisions. The medical power of attorney is assigned as long as that paperwork exists. There's no expiration. It's either the patient dies or the patient may revoke it and redo the paperwork and assign it to somebody else. But if those things do not happen, then whoever is written on that piece of paper is who is the legal medical decision maker. The medical power of attorney is only called upon when the patient cannot speak for themselves. So if they have a power of attorney assigned, but they're able to make their own decisions, then we talk directly to the patient and they make their own decisions, and the medical power of attorney does not have any say in what is going on because the patient's competent in making their own decisions. So you might be thinking, well, who do I select to be my medical power of attorney? So this is a personal choice. It is somebody that you trust to execute your wishes as written. It would be somebody who, if you were critically ill in a situation where you cannot speak for yourself, you trust that this person will be your voice and say, this is what they've told me in the past, this is what's written in their directives, so this is what we are going to do. So obviously you want to tell your medical power of attorney what your specific wishes are in different scenarios, and it would be best to ask this person, if they're willing to do that for you, because some people do not want that responsibility of having the medical team calling them and asking them, these are the things that we'd like to do. Do you give consent or not? And we involve the medical power of attorney in making a lot of end-of-life decisions if the patient cannot speak for themselves. So these are very difficult and heavy decisions. So you want to make sure that they know what you want and that they're willing to be your voice in these situations. So that would be the first route, is finding if this person has any written directives. Many times it'll already be in our hospital chart if they're somebody who frequents our hospital system, or if their primary care physician is linked to our healthcare system and they've already filled it out with their primary care doctor, or if many times patients, if they know they're coming to the hospital, they'll bring in the paperwork, or their medical power of attorney will come and bring the paperwork once they know the patient has been hospitalized. So as long as we have a copy of that paper and we see the legal document, that person is the decision maker. Many times people select their spouse or an adult child or one of their parents, so it is typically somebody related to them, but there are situations where somebody has selected a friend, one of their pastors, so you can pick anybody over the age of 18. So in the event that somebody has not completed this paperwork, we go to what is called the next of kin. This is the next person directly related to this patient who is over the age of 18. The next of kin I'm going to go through is specific for my state. It varies state by state, but overall the order is typically the same. And the order I'm discussing is in the case of an adult patient. If the patient is a child, most likely the next of kin is the parent, and then goes on, but I know there's a slight difference when it is a child. So the first person that we try to locate is the patient's spouse. So, which is the obvious choice, whoever their partner is and they're legally married, we seek this person out, and many times they would have been the person who brought them to the hospital anyway. Some things to note with this: If the patient is not legally divorced but separated or estranged from their partner, it does not matter how much time they've been separated, they're still legally married and they're still the legal decision maker. We can go to that person and they say, I haven't seen this person in decades. I don't want to make their medical decision. I'm going to defer to somebody else. That's fine. But I have had situations where we've found a husband who has been estranged for 20 years who was like, yeah, I want to make their medical decisions. So that's something to keep in mind. If you're not legally divorced, then your spouse, whether you're separated, estranged, or if they're in the picture or not, it does not matter. They are still legally your spouse, so they are still legally your decision maker. Another situation is common law marriage, because some people will come and say, we're common law, but common law marriages do not exist in all states. This is a misconception. Some people believe if you've been living together X amount of time, then you're common law married. I previously practiced in North Carolina in my past job, and we did not recognize common law marriages. We only recognized legal marriages. So if somebody came and they said they were common law, then they were not able to make the medical decisions. We had to go to the next person in line. But I currently practice in Texas. We do recognize common law here, so the common law spouse can make decisions. If you believe you're in a common law marriage, just know the laws in your state of whether they recognize that or not. So after that, if they're legally divorced, if they're not married, or if their spouse has died, then we go to the adult children. So this also has a slight variation state by state, which child is making the decision. But in the state of Texas, we ask all children if they want to be involved in the decision, and it has to be majority rules. So if there are 5 children, at least 3 of the children have to agree on the decision to move forward with that choice. The next in that order is the patient's parent, if they are still alive. And then their siblings, if they have any siblings, if they're still alive. After that, we try to find the next living relative. It could be an aunt, a cousin, and then we look for close friends, neighbors, clergy. So the list goes on, and like I said, it's different state by state, but overall, this is the order. And of course, if we go to somebody and we say, you're the next of kin, they can say, I do not want to make any decisions for this person. Can you please find the next in line? So they are not forced to make a decision. They're just the next one who is offered the opportunity to make decisions for the patient. All this goes with saying, if you do not like this order and you would prefer the person who is first, second, third in line to make your decisions not to, that is the importance of having advance directives and a medical power of attorney, because the medical power of attorney trumps all of this. And then the final situation is, what happens if there is no one to make a medical decision for this patient? So as I've said in prior videos, our default is when somebody comes in with an emergent situation that needs to be acted on quickly and it's time sensitive, then we just go forward. If they need an emergent procedure, we do it. If they need an emergent surgery, we do it, because even if they have a medical power of attorney or next of kin, and time is precious, we don't want to waste time calling these people and asking for consents and explaining the situation. If it's life and death in a matter of time, we just do it, because we know any reasonable person would agree to having their life saved rather than letting them die. There are some situations where I have done 2 physician consent for somebody who we have not been able to find a family member or next of kin, and it was time sensitive but not emergent, for situations such as somebody needing urgent dialysis because of kidney failure and knowing if they didn't get it soon they may die, but it wasn't life or death that needed to happen right this minute. Same thing for surgical procedures. If there's a little bit more of a window, we try our best effort to get in touch with any family or next of kin. But if that does not happen, then 2 physicians can come together and say, I think a reasonable person would agree to this life-saving procedure or life-saving treatment. There are also situations where we may go to the ethics committee within the hospital. There is an ethics committee at every hospital, and say, we've done our due diligence in trying to find this patient's family and next of kin. We have not. This is the situation. And the ethics committee guides us in terms of what is ethical to do in a situation where somebody, is sustaining on life support, not improving, and has irreversible disease. Those are typically the situations in the intensive care unit, is if somebody's not getting better, it looks like their life is on life support. Trying to say like what would a reasonable person want in this situation, because withdrawing life support is a pretty big deal and we don't want to make that decision without anybody to speak for the patient. But like I've said multiple times, whatever the life-saving thing to do is, that's usually what we move forward with. And something else that may happen is, this is a long process, so it does not necessarily happen in hospitalized patients, but it can, is getting a court-appointed guardian. So if somebody absolutely does not have any family, friends, anyone to make decisions for them, they're not able to make decisions for themselves, they might have somebody assigned by the court who is their guardian, and they make all of the medical decisions for them. We work very hard to find family and friends and anybody who would be able to make decisions for the patient. We typically have a social worker assigned to the patients in the intensive care unit, and that is one of their duties, is to find family. And like I said, if we don't have an answer, we do everything to maintain that person's life until we can find somebody to make a decision for them. This is a very complex topic, and as I said, it does vary state by state. I encourage you, if you had any questions about your specific state, to look on your state's website. A lot of times they will have next of kin listed out. If you wanted any more information about advanced directives, medical power of attorney, I'm going to leave some resources down below. If you have any questions, feel free to ask me. This is a very brief explanation of something that is complex. I'll see you on Friday for the next video.